is for the court to analyze that evidence. What this witness is now doing is embarking on a process of analyzing evidence, which that should be left for the court after the court has been after the court is seized with that objective evidence that came from the investigating officer. It is not their duty to assist the court on how to analyze that evidence. They are taking over what the court is supposed to be doing. We are expecting Mr. Gininda to say, in the course of our investigation, this is what we found. This is what we found. This is what we found. This which we found is how we connect accused number 1. This is how we connect accused number 2. This is how we connect accused number 3, 4, 5, etc. It is not for him to come and opine how the evidence that he found is relevant with the connection of each of the accused persons. It's basically usurping the duty that the court should embark upon after having had all the evidence at the end of the case. I'm strongly objecting to a process that this witness is embarking upon.
So this row is brought about Gininda trying to take over and analyze the evidence in a way that will influence the court, the judge per se. It will influence the judge in his case findings. Gininda ngempela, I don't know, he's taking us for fools. Now remember when he was talking about the confirmations, right? So the first accused confirmation made mention of Marco and the other guy. Who was it? I don't recall the other name. So, and only to find that those people, one of them was in jail. All right, it was jailed in 2013, and now if you're saying you are spitting the facts, and the facts, they do corroborate with the statement of the people who were inside, how did you not find out that the person that the accused number 1 is mentioning was already in jail by that time? How could you not know that if you were a true investigating officer that you claim to be of the caliber subsequent to the corroboration of your thoughts and facts? Sifelani ngempela nge-subsequent ne-collaboration. And uyabona lana, Mnisi caught them. They are so sneaky, and Mnisi managed to get them, because now what he's basically doing is to give his opinion and he's giving his views. But if his findings and the evidence that he brought to the court, it's so credible, that would be determined by the judge. It's not for him to tell the judge how credible his findings were. They should speak for themselves, So cabanga ukuthi silele, umnisa kalalanga shame. Baba Gininda, assist the court with the facts only and nothing else, please. Okay, Baloyi and Gininda, we hear you, we see you. We see exactly what you're trying to do. We see that exactly. You're trying to rubbish case 375. You're trying to pen and influence the judge. I know the judge would say he's experienced. He does have his mind of his own, but we can see what you're trying to do in a way. We are seeing you, some of us might have been born at night, but definitely that doesn't mean that we were born last night. Okay, so put some respect on our IQs. Now let's take a listen to Advocate Baloyi's response towards that.
We looked at section 209, which we read in the report, and what this witness is merely saying is contained in section 209. That is the first of all that the witness regarding the fact that in his view, when reference is made to a person with dreadlocks, is just enough. All that he's saying is that the evidence established that the person who had dreadlocks is accused number 3, and we refer to the relevant photo, which is not disputed, that shows that accused number 3 had dreadlocks. That's all that the
is doing. And secondly, we indicated, my lord, in the beginning that the version of accused number 1 is that he's not the source of this confession. Now, all the exercise that this witness is embarked upon is to indicate that accused number 1 is the only person who could have been the source of what is contained in this document. This the exercise that Brigadier Gininda is busy with.
Gininda thinks now LLB yakhe put him at par with the advocates there at the bench. I think so. Listen to what he's saying now.
Of the name Senzo Meyiwa. Around that period of October 2014, my lord, the only Senzo Meyiwa that was shot and killed in Kosaras is the deceased, the matter that we are dealing with, my lord. In other words, my lord, I'm saying there are no different deceased with similar name and surname that were killed under these circumstances in that area in the month of October or September 2014. It's only this deceased. So an inference can be drawn that he was referring to this particular matter. This witness simply refers to an inference. Who is seized with the functionary of drawing inferences? It is not him, because that is not a fact. What he's presenting now, he says an inference can be drawn that it was. And now I'm not even so sure whether he's aware of Arvesa's blom on the drawing of inferences. So he can't just stand there boldly and say an inference can be drawn that it is him. It is for this court, my lord, to deal with the question of inferences after the state has requested that the court should draw a particular inference, not a witness who's an investigating officer. Him is to bring facts before court, not to tell this court that it should draw inferences. This is highly irregular. Thank you.
Siyabonga Advocate Mnisi, uqondise igwegwe and bring about the correctness and some respect to this court and processes, because Judge and Baloy, they are not willing to do that. And yeah, thank you so much guys for watching. Just remember to drop a comment on the comment section, like the video, and hit that subscription button to become a member of this channel. Until the next video, keep watching and keep peace.